there are three cases that you really need to know about, all House of Lords cases, prior to Paul Polmear and purchase. The first of which was McLaughlin. Now, some of you might remember the facts of McLaughlin. For those of you who do not, they were these. The claimant's husband and children were severely injured and or died in a road traffic accident. They were taken to hospital, and so the claimant, who suffered the psychiatric injury, the wife, mother, didn't witness the accident directly, but came across them in hospital where they were covered in both mud and blood and suffered nervous shock as a result. Lord Wilberforce gave the leading judgment in that case and summarised a century or so's worth of jurisprudence as follows. First of all, this type of claim, a nervous shock claim as they were then called, could be made without showing direct impact or fear for injury to yourself. Secondly, that such a claim could only be brought by a relative. And thirdly, that you had to come across you had to either be there or be within the immediate aftermath of the accident. And there was also a fourth one, which isn't on the slide, which was that there was a separate category of claims for rescuers. Now, the House of Lords in that case were fearful of extending the limit for secondary victim claims any further for four reasons. First of all, there was a fear of fraudulent claims, slightly bent lawyers and or psychiatrists concocting those types of claims, and a cottage industry following thereafter. Second of all, extending the limit of secondary victim claims would mean that damages might be out of proportion to the negligent conduct complained of. Thirdly, that the evidential difficulties would be increased, and there obviously would be the knock-on effect on litigation as a result. But fourthly, and it's in bold there because it is perhaps the most important reason, is that that type of radical extension of the law should only be made by the legislature. So with that in mind, the House of Lords began the story of control mechanisms by imposing three of them essentially. First of all, there had to be a close, most likely family tie to the primary victim. That's pretty well understood by most people. Second of all, there had to be proximity both in time and space. And that really is the key issue that's dogged the courts throughout and up until January. And thirdly, and related to that, you had to come across the event or its immediate aftermath. It's related, obviously, because the definition of what the event is or proximity will define what the immediate aftermath is as well. We then move a few years on to perhaps the most well-known secondary victim case, at least from law school days, the case of Alcock, which arose from the Hillsborough disaster. And Lord Oliver's speech in that case is the most famous. And these five control mechanisms, well understood by those of us who work in personal injury and clinical negligence secondary victim claims, have been pretty much a mainstay since the early 90s. You've got love and affection at number one, but second of all, that the shock or injury must have come through the claimant's unaided senses, i.e. not perception by TV or communication over the telephone, for example, but importantly, that it had to be sudden and horrifying. And we'll come back to that. Thirdly, the claimant had to be present at the scene of the accident or witnessed its aftermath. Fourthly, that the injury arose from witnessing the death of, extreme danger to, or injury suffered by the primary victim. And fifthly, there had to be an element of physical proximity to the event and a temporal connection between the event and the claimant's perception of it. Now, I'm going to pause there because those of you who are listening closely will notice that I've emphasised the word event and accident, and there is, for reasons we'll come on to, a tension between those two phrases, which has been the heart of the problem for a good 20 years or so, or longer. The third of the House of Lords cases was a case called Frost, also known as White, against the Chief Constable of South Yorkshire, another set of cases or claims that arose out of the Hillsborough disaster. That was a claim or set of claims brought by the police officers who suffered psychiatric injury arising out of that disaster. And the House of Lords did three things. The first thing they did was to confirm the control mechanisms which I've just outlined in Alcock. So they were now settled law by the end of the 90s. Second thing they did was they properly defined what counted as a primary victim. And the reason they did that was because the police officers, given that they weren't related to the victims of the Hillsborough disaster, said they wouldn't satisfy the love and affection tie. So they said they were primary victims. Not so, the House of Lords said. A primary victim had to be a person exposed or perceived themselves to be exposed to physical danger, and they didn't satisfy that requirement. And the claims were rejected, not least because, and this is again important for reasons we'll come on to, allowing them to claim would offend most ordinary people's sense of justice, i.e., if the loved ones of those who died at Hillsborough could not claim, it would make little sense, or it would be offensive to most people's sense of justice if the police officers could claim. And that sense of what an ordinary person would consider reasonable, again, has been a guiding principle through the jurisprudence, as I think Sophie will unpack later. So I'm not going to take you through all of those control mechanisms today. The ones we're going to focus on, because they are what the Supreme Court really narrows down on, are firstly what counts as a sudden appreciation or a horrifying event, and secondly, what qualifies as an event. So dealing first with what counts as being sudden and horrifying, a recap. Up until January, a claimant had to prove that the event had to be horrifying enough, and these are the quotes from the law, to violently agitate the mind or as a sudden assault on the nervous system. And we all understood that up until January to be an objective standard, and it was a high bar to get over. I've put some cases on the slides there to serve to paint a portrait, as it were, of what the courts mean. So, for example, Taylorson was a case where the claimant's son was crushed by a reversing vehicle. The parents caught brief glimpses of their son whilst in ICU and stayed with him for 3 days until he died. That was not a sudden enough event for the court, or for the claimant rather, to qualify as a secondary victim. Syon and Hampstead was a case, again in the mid-90s, which arose out of a failure to diagnose a heart condition. And the claimant witnessed her husband having a heart attack. Dying. Sorry, that's not the heart attack case. Syon and Hampstead was a case where the claimant's son was injured in a road traffic accident and suffered a kidney bleed as a result, which was missed by the hospital. The father stayed at his son's bedside for a number of days until his son died. And again, that was neither sudden nor horrifying. Walters is a case which many of you will be familiar with and which we'll come back to, but that was a case where a child had not been diagnosed with hepatitis. The mother, who was holding the newly born child in her arms, woke up next to it to find it fitting, and 36 hours later, the child tragically passed away. That apparently was one event referred to as being a seamless tale with a very clear beginning and end. And then there was the case of Renane, another case arising out of a clinical negligence case where the claimant's wife had septicemia, peritonitis after a negligently performed hysterectomy. And although she has been very ill and in a terrible condition, that was not a sudden or a horrifying enough event, given that the setting was in hospital. It wasn't exceptional. So that serves to paint a picture of what the court meant. But the key change or issue in Paul, and that really has dogged many secondary victim claims to date, has been what counts as an event for the purposes of a secondary victim claim. If the breach of duty is synchronous with the damage, so for example, in a road traffic accident, there isn't much of a debate. But life's never that straightforward, or the law's rather not that straightforward. So there have been a number of cases which have grappled with the question of the breach of duty being separated in time from the death or catastrophic injury sometime later, days, weeks, months, etc. And we're going to go through 3 cases, and we're going to go through these cases because these are the cases that are important for understanding the Supreme Court decision. The first in time is a case called Taylor and Somerset Health Authority. Now, that was the heart attack case that I was getting confused with earlier, where a wife, there was a failure to diagnose a heart condition, and the claimant, the deceased's wife, saw the heart attack take place and the subsequent death. That claim was rejected by Mr. Justice Auld for 2 reasons. Firstly, the event for the purposes of a secondary victim claim needed to be an external traumatic event caused by the breach of duty, which immediately causes injury or death, i.e., a deterioration in one's condition could not count. And then there needed to be perception by the claimant of the event as it happens. So that would be the external event. And in this case, there wasn't such a thing. There was a progressively deteriorating heart condition over a period of months, but there wasn't an external event, and therefore the claim was rejected. The second case was Walters. Now, like I said, that was a case where the defendant had failed to diagnose the child's hepatitis. And Mrs. Walters tragically woke by her baby's bedside when he was suffering a fit. And tragically, that baby died some 36 hours later. That case reached the Court of Appeal, who held that you had to look at the totality of circumstances, and taking a realistic view of things, the law couldn't take an event as a single moment frozen in time. And one of the key passages from that case is up on the slide there, because it's referred to by the Supreme Court, was that this case was an inexorable progression from the moment of the fit, causing brain damage, and to its dreadful climax when the child dies in his mother's arms. It was a seamless tale with a beginning and an end, and it was one drawn-out experience. I've highlighted those phrases, firstly because they will be phrases that are familiar to us who deal with secondary victim claims, but secondly of all, the Supreme Court, as Sophie will explain, had some quite pointed comments to make on that description. So then we come lastly to Taylor and Lenovo. Now, this wasn't a clinical negligence case. In this case, the primary victim suffered an accident at work when some shelves fell on her. She suffered some damage to her neck, her shoulder, and her arm. I think 3 weeks later, she suffers, however, a pulmonary embolism, and her daughter, Mrs. Taylor, brings a claim because she witnesses the pulmonary embolism and death of her mother and suffers injury. So the question for the Court of Appeal to grapple with was, is the event for a secondary victim claim the breach, so the failure to stack the shelves properly, or is it the collapse and death that resulted some 3 weeks later? Lord Dyson gave the only judgment in that case, and he started by explaining that proximity, which is a key requirement, has two meanings. It firstly has a legal meaning, and by that he means that is it fair, just and reasonable to impose a duty? The second is more pragmatic, and that is talking about there has to be proximity in time and in space. In this case, he held or commented that the focus that we as lawyers had on the word event was in fact a distraction. Instead, what you had here was an accident with two consequences separated in time. And that, given that that was the case, the claim had to fail for two reasons. Firstly, there was the slippery slope argument. Well, if we're going to extend proximity in time and space to a period of 3 weeks, then how much longer are we going, further along are we going to go? Remember, up until this point, McLaughlin was all but at the limits of what proximity in time meant, and that was a case involving a couple of hours. Even Walters was a period of 36 hours. So going along by 3 weeks would be a serious and radical departure from the case law up until that point. But secondly, allowing the claimant to claim damages in that case might offend ordinary people's sense of justice in this way. If it was the case that the secondary victim, the claimant, had come upon her mother, say 6 hours after the accident, and sees her mother dead, either in the mortuary or otherwise, then she wouldn't be able to claim, because she neither would have been there, nor would she have been in what would commonly be understood to be the immediate aftermath. So therefore, it wouldn't make sense to allow her to bring a claim when she suffers the injury some 3 weeks later. Those two hypotheticals would be a contradiction. So for that reason, Lord Dyson took it that the event was the accident, and therefore the claim had to fail. Now you might ask, well, what did the Court of Appeal do about Walters? Because that would seem to be slightly contradictory to all that I've just said. Well, Walters was distinguished on the basis that that was, remember, a seamless tale with an obvious beginning and an obvious end. But in this case, you had two distinct events separated in time and space, so it was very different. So up until January, that's a very potted history of the law on secondary victim claims. And then we have these three cases. I'll run you through the facts because they are germane to some of the comments the Supreme Court makes and the arguments. In the case of Paul, the father who died, again, much like one of the earlier cases we discussed, had a heart condition which had not been diagnosed. His two daughters, after hearing screaming outside, exit, I believe, the shop they were in or home they were in, to see their father on the floor, bleeding from his head and being resuscitated. They see the ambulance crew there with foil over their father and doing compressions, and they suffer injuries as a result. Polmear was a case involving a girl called Esme Polmear, who was seen by her GP a number of times with what were called strange episodes. She was having difficulty breathing, was looking pale and blue after only a few minutes. No diagnosis was made, and she was on a school trip some weeks later. She was extremely weak, vomiting, going white, clammy. Her father was called, who arrived and who carried her back. He left her with, I think, staff members and began to take a call. As he turned around to see his daughter being given compressions, and although Esme went to hospital, she tragically died. In Purchase, it was a similar-ish case in that there was a deterioration in the condition of the victim, Evelyn, and she deteriorated over a number of months, feeling weak and unwell. The claimant, her mother, attended an event in London, leaving Evelyn at home with her father, and she returned the next morning to find Evelyn, her daughter, not moving, and that when she attempted to resuscitate her, blood and bodily fluids came out of her mouth and nose, and although the paramedics arrived, unfortunately it was too late. The tragedy was compounded in that case by the fact that only moments before she arrived back home, her daughter had left her a voice message on her phone with what turned out to be her last breaths. So those are the facts. All three made their way through the courts until we get, I think, to the Court of Appeal. And the arguments were many, but from the judgment, the three ones that were the ones that we want to focus on for the purposes of today, perhaps, were these. In secondary victim claims, you sometimes have three types, or it appeared there were three types of cases. You had your pure accident cases, so a road traffic accident, and either the secondary victim is there or arrives at the immediate aftermath, straightforward legally. You then had the interval cases, the clinical negligence cases we were talking about, such as Sion and Walters and the like. And then you had the cases such as Anovo, which wasn't a clinical negligence case, but appeared to have two separate events. The claimant's legal team for Paul argued that the event for the purposes of a secondary victim claim was when the damage becomes manifest. So in their case, with the heart attack, the damage was becoming manifest at the time of the heart attack, and therefore the daughters were either at the event or within its immediate aftermath. That argument wouldn't ground a claim for Polmear and Purchase, however, because there was a deterioration in Esme and Evelyn's condition over the weeks since the misdiagnosis or failed diagnosis. So they argued that any horrific event was sufficient, namely the death and or catastrophic injury. And the defendant to that argued that the event was the time of the accident, and you had to narrowly define what was meant by an accident. And the Court of Appeal clearly had their sympathies with the claimants, and certainly with Polmear and Purchase. The Master of the Rolls saying this, that if he was coming at it with a blank slate, it was hard to see why the gap in time should defeat a claim. He was referencing specifically Taylor and Anovo. So if he was dealing with a blank slate, he said that all it should take to ground a secondary victim claim would simply be that the consequence of the defendant's negligence was close in time and space to the psychiatric injury, the consequence being the death, and that the secondary victim was either personally present or in the immediate vicinity of the same. Lord Justice Underhill agreed, and they took the view that making that decision wouldn't be contrary to the thus far and no further approach established, what was then referenced as White, but the Supreme Court references Frost. It wouldn't be offending the control mechanisms or elements in Alcock either, but they were bound by Anovo, and therefore they had to side with the defendants. However, unsurprisingly, permission to appeal was granted, and that is when I'm going to hand over to Sophie.
So thank you everyone for joining us, and thank you, James, for taking us to that point, to the point of the Court of Appeal decision. turning to the Supreme Court decision itself. Now, it would be fair to say that it is a decision that has divided opinion. And I have put on the first slide quotes illustrating this division. Now, they are extracted from the Law Society Gazette article last week by John Hyde and are reactions from senior practitioners in the clinical negligence field. And first, there have been few times in my career when I have felt genuine embarrassment at the state of the law. This is one of them. Contrasted with the decision by the Supreme Court provides welcome clarity for lawyers and their clients. So in terms of our roadmap for the second half of this webinar, what we're going to start by looking at, I'm just going to start by looking at the broad brush outline, or what I'm calling the equivalent of the Cliff's Notes of the decision, of which many of you will doubtless already be aware. We're then going to move to look at some of the details of the decision, which obviously have ramifications for wider personal injury litigation of secondary victim claims, both within but also beyond the field of clinical negligence. And we'll then briefly turn to considering what may remain of secondary victim claims in the clinical negligence field. And then finally, for balance, and also because it may well be of interest, I'm going to review for you summarily the dissenting opinion of Lord Burrows in Paul. Now, as I said, you may well be aware already of the outline of the Supreme Court decision in Paul. It has probably or possibly already had significant implications for some of your clients. Now, that decision was reached by a majority of 6-1. What was said in Précy, I've put on the slide. A person who suffers psychiatric injury from witnessing the death of a close relative or its immediate aftermath from a medical condition which a doctor or health authority had negligently failed to diagnose and treat. Now, they are not entitled to claim damages as a secondary victim. There are, oh, their slides are not moving. There we go, there. Now, there are definitely two camps of reactions. Hopefully the slides are moving now. For some, this will be seen as a rational public policy decision that protects clinicians and the NHS against a disproportionate burden in a time where that's necessary, preventing proliferation of claims, which could, depending on how obviously the boundaries were drawn, they could be substantial, and for some safeguarding public funds for treatment for people's mothers, fathers, their social care, etc. That necessitates a drawing of this line in the sand. But for others, the decision is seen as arbitrary, as seen as unfairly excluding legitimate claims made by vulnerable individuals for readily foreseeable consequences of negligent conduct. Now, it doesn't appear on the face of things to matter how extreme or serious the clinical negligence, how repeated, sustained or gross that conduct, or how severe and devastating the psychiatric injury that arises to the secondary victim, or how much loss has been caused thereby, and that there's no other source of funds to make up for that loss. Where diagnosis and hence treatment is negligently delayed, and as James correctly noted, these are all treatment delay type claims, they're omission type claims, and death or injury arise as a consequence, there is simply no entitlement to claim for psychiatric injury for secondary victims witnessing that death or serious injury. So there was no claim for the 9 and 12-year-old daughters who witnessed their father's heart attack in Paul. nothing for the parents who saw their 6-year-old daughter's collapse and death in Polmear, and nothing for the mother who comes upon her 20-year-old daughter a handful of minutes after her death from severe pneumonia in Purchase. So that's the headline. Now for the detail. We're going to now look at what Paul confirmed is the framework for secondary victim claims. So these are really the take-home messages for today. So notwithstanding nor detracting, obviously, from this important decision insofar as it relates to clinical negligence matters, it should be noted that Paul does leave altered, or some people would say confirmed, depending on what side of the line you sit on, the framework for secondary victim claims in the wider personal injury context. So I'm going to take some time setting out that altered framework because it is important. The first point of note, and that's at the headline of the slide, is that secondary victims can claim for physical and or recognised psychiatric illnesses. Now that sounds really obvious, but the point being made is that a claim can be brought for physical injury alone in this context. And the court traced a line of historic case law, noting that in none of them is it treated as material whether the injury for which compensation is claimed was psychological or physical, and they put deliberately in brackets insofar as any clear distinction can be drawn. And that's vividly seen, most vividly in the case of Hambrook and Stokes brothers, which is a 1925 case. And that was one where a mother suffered a severe hemorrhage, so a purely physical injury. And she then died from shock caused by fear for the safety of her children. And the Supreme Court here explicitly recognised that secondary victims may claim for physical injury alone and or recognise psychiatric injury. So thus, whilst the focus will more commonly be on psychiatric injury in secondary victim claims, there isn't an apparent barrier for a claim for purely or mainly physical injury to a secondary victim that comes about not as a result of direct physical injury in the accident, because otherwise they'd be a primary victim, but as a result of their witnessing an accident to their loved one. So that was the first key point of note. The second important clarification made in Paul, and it builds on what James was saying, is that there is apparently no requirement for the claimant to establish that their injury arose as a result of a sudden shock to their nervous system. Albeit that, exactly as James highlighted, the phrasing adopted in Alcock as the second requirement is the secondary victim having to demonstrate that their injury, and quoting directly from Alcock here, arose from the sudden and unexpected shock to the plaintiff's nervous system. So it's not that surprising that we've all been thinking that it might have formed part of the test. The Supreme Court rightly, in my view, recognises in Paul that the term nervous shock arises from a crude, old-fashioned mechanical modelling of psychiatric illness, attributing psychiatric illness to an almost physical assault on the nervous system. And the Supreme Court recognised that has long since been departed from as an appropriate analogy for the causation of psychiatric illness. The court preferred in this case, the rewording of the Alcock decision set out by Lord Hoffman in Frost. It was called White in the Court of Appeal, it's called Frost in the Supreme Court judgment. And that is the test they endorse as authoritative in Paul. So I've put that on the slide. You know these because they are things that have been said for a long time about secondary victim claims. But what they take out is they take out certain elements that we believed were part of the test, such as sudden shock. And I'm going to go on to horrifying in a moment. So what it says is the Frost framing, the plaintiff must have close ties of love and affection with the victim, be present at the accident or its immediate aftermath, and the injury must be caused by direct perception of the accident or its immediate aftermath. Very tight, very narrow. This reworking doesn't include the requirement that the claimant's psychiatric injury must have been caused by a sudden shock to the nervous system. So they've got rid of that in its entirety as a requirement. For the same reasons, it's also said in Poole that Frost imposed no requirement that the accident being perceived was horrifying, that it was a horrifying event. The court is instead restricted to considering whether the claimant has shown simply that it was reasonably foreseeable that the defendant's negligence might cause the claimant injury, acknowledging, they do, that if, for example, a claimant with a history of psychiatric illness develops such an illness after witnessing only a minor accident in which, for example, his wife sustains cuts and bruises, that claim might fail that test of reasonable foreseeability. So it doesn't, and I think this is something important to note, it doesn't get rid entirely of the need for an accident of a certain level of severity. What it does, though, in my view, is actually lower the certainty in these types of case, because what is reasonably foreseeable, when is psychiatric illness reasonably foreseeable as a reaction? We no longer have that threshold defined, and it will be interesting to see how that might develop over time. Now, the removal of these two aspects, the sudden shock and the requirement for a horrifying event, might benefit in some cases. But whilst the first two clarifications made in Poole, they broaden the categories of event that may qualify. Poole, overall, it definitely confirms a radical narrowing of the range of individuals or other circumstances which may qualify as secondary victims. That is likely to heavily benefit defendants. As Poole emphasises, one of the vital necessary, so this is the way they went with this, the vital necessary qualifying criteria for founding a secondary victim claim is the witnessing of an accident, defined critically as an external event and/or its aftermath. Their lordships highlighted that medical negligence cases such as Walters, and James went into the facts of Walters, so that was the one where a mother recovers for psychiatric injury sustained as a result of watching her young infant's traumatic seizures in their last 36 hours. The Supreme Court says in Poole effectively that Mrs. Walters should not have succeeded, saying that such cases that treat the traumatic scenes witnessed over several days as comprising an event founding liability appear to have led to an extension of the aftermath of true accidents to a period far beyond what was contemplated by Lord Wilberforce in McLaughlin. And what the Supreme Court decides instead is it focuses us back on the test as articulated in Frost and the use of the word accident as distinguished from injury and as distinguished from event. And the Supreme Court defines accident, and I've put one quote on this slide and there's one on the next slide because there's two passages in the judgment where they define what they mean by accident, and I think they're both important. An accident is an external event which causes or has the potential to cause injury. It's not the injury, if there is one at all caused by that event. So it's the accident or its immediate aftermath that must be witnessed by the secondary victim, not the injury, the death of their loved one. And it's important to remember, I think to pause here to remember that injury itself doesn't need to be witnessed. So they said within that quote, it is not the injury if there is one. because claimants can and can still succeed where the claimant simply fears for the safety of their loved one, but no injury is in fact then sustained by the other person, where in fact there is no primary victim. And logically, it might be easy to see why this analysis appealed, because it is a substantial narrowing. It does give a significant degree of certainty. I've set out the further passage on this slide because it will be required for all secondary victim claims going forwards to understand. This is paragraph 108 of the Supreme Court judgment, the definition of the term accident. And this is the more extended version of that definition. An accident is, and I haven't got rid of any keywords here, I've just condensed it so it fits on the slide, a discrete event in the ordinary sense of that word, something which happens at a particular time, at a particular place, in a particular way. Whether someone was present at the scene and whether they directly perceived an accident are in most cases questions which admit of a clear and straightforward answer. So we look forward to seeing how straightforward that is going forwards when we're litigating cases. I'm going to spend a moment on the term aftermath. I note when we consider what constitutes the aftermath of an accident, the court in Paul highlights McLaughlin, and not Walters, McLaughlin, where the claimant learns of the accident, is told her daughter is dead, her other children are still grimy with dirt when she sees them 2 hours, but only 2 hours later. And in McLaughlin, and repeated in Paul as important, it was said that that was upon the margin of what the process of logical progression would allow. So that's at the edge of what the aftermath is. And they said it's important that the children were sadly in the same condition as they had been at the roadside, covered with oil, mud, distraught with pain. So there's a strong emphasis in Paul on drawing the boundary of the immediate aftermath very tightly. And the justification given in Paul for an accident as opposed to an injury, so for their decision on that point, are threefold. First, legal certainty over who qualifies. Well, it certainly narrows down that category. Secondly, avoiding the difficulty encountered in accident cases. So effectively, this is saying we need to keep some secondary victims because in accident cases, there can be a difficulty in distinguishing between who's a primary and who's a secondary victim and what injury has been suffered as a result of damage to yourself and what as a result of fear for a loved one. And that's therefore why one needs a category of secondary victims. And thirdly, and this is a quote and it's more controversial, most people would, they say, we think, accept that if a line is going to be drawn between cases where illness consequent on bereavement is compensable and cases where it's not, distinguishing between claimants who suffered the ordeal of actually witnessing the accident in which a close relative was killed and those who did not is an intelligible place to draw it. So that's the Supreme Court's reasoning why they select accident rather than event, rather than any other type of wider definition. It's really important to note that the focus on accident means that actually there can be a gap in time between the defendant's negligent breach of duty and the actual accident. So there's no requirement of closeness in space and time to the defendant's breach of duty. And the examples the court gave, they used Hillsborough. They said if breaches of duty in the planning of the event, if they had been what led to this devastating crowd compression, they would, the actual accident itself was at the time of the devastating crush. So there could be this gap between breach and the accident itself. Similarly, Taylor and Novi, where the shelves, the racking boards that injured Miss Taylor had been, if they'd been negligently stacked many years before they fell, that wouldn't alter the fact that the later accident itself, when the boards fell later, if that had been the permutation, if witnessed by a loved one, might have founded a secondary victim claim. So it's the accident that is the central point here. I've come full circle back to the précis of our decision itself. We've got delayed diagnosis cases under consideration, and they, by their very nature, manifest injury without external accident. Death or serious injury arises as a result, obviously, of internal processes, the disease processes going untreated. And so they don't meet the qualifying criteria of witnessing an accident if we define that as an external event. Now, you will doubtless, and I've already been asked, have clocked that there are a range of clinical negligence cases derived which aren't analogous with pool purchase Polmear scenarios. These are all delayed diagnosis cases, the consequences of failing to treat. And the question was raised, it was raised in argument in Pool, of whether the rules governing secondary victim claims arising from accidents could ever apply in a medical setting. And they looked at a number of hypothetical examples, perhaps the wrong dose of a drug being given at the wrong level and inducing an acute reaction that was witnessed by a relative at the time. And the court just didn't address that. They said best left to be addressed in a case where they actually arise on the facts. So there's a lack of clarity there for practitioners. I think, though, relevant to the issue of how those types of claim might be received, and I stress this is my view, and there may well be a lot of further thought to go into this, are probably the Supreme Court's conclusions in relation to the lack of duty of care owed by medical practitioners to patients' families. So the court considered the scope of the duty of care owed by medical practitioners, and what they concluded I've set out on the slide. They said they were not able to accept that the responsibilities of a medical practitioner extended to protecting members of the patient's close family from exposure to the traumatic experience of witnessing the death or the manifestation of disease or injury in their relative. And they said to impose such a responsibility, this isn't on the slide, but this is what they went on to say, to impose such a responsibilities on hospitals and doctors would go beyond what in the current state of our society is reasonably regarded as the nature and scope of their role. Now, my preliminary view, and I stress this is preliminary, is that it could, in light of that aspect of their determination, be difficult in the event of medical accidents, even of the non-omission type, to conclude a duty is owed, with the court potentially preluding a carving out of some kind of medical practitioner exception, but that is not clear. And there may well be exceptions to this, in my view, where a duty could be owed as having been assumed as a result of proximity between the secondary victim and the medical practitioner and the relevant negligent act or accident itself. So there may well be cases that will fall within those boundaries. I don't think this is the last that we've heard of clinical negligence claims and involving secondary victims. Moving then and finally to the final section of the talk on the dissenting judgment. So there was a 6-1 majority decision and one dissenting voice. And the dissenting voice, it's interesting who the dissenting voice was. It's Lord Burrows, and you will have read hopefully his decision, but if you haven't, it should be noted that he was the Law Commissioner in charge of the Law Commission report on liability for psychiatric illnesses that was drafted 25 years ago as Frost was just coming through the courts. And what was suggested there was that there should be a new statutory duty of care, allowing claims for those who suffered reasonably foreseeable psychiatric illness as a result of the death, injury or impairment of the person with whom they had a close tie of love and affection, and that should be regardless of their closeness in time and space to the accident, closeness to its aftermath, or the means by which the claimant learnt of it. Now, that Law Commission report had been published, but was yet to be considered by the government at the time the decision in Frost was made. And the decision in Frost, the Lords have recently endorsed in Poole, was given by Lord Stein. And what he said was it must be left to Parliament to undertake the task of radical law reform. And then it went to Parliament, the government considered it, and the government's response came back. They threw it back to the courts to deal with the matters flexibly as they arise. So the nettle of potential reform, not grasped 25 years ago, and Lord Burroughs laments that 25 years on, there is this doubling down on the status quo. He notes in his dissenting judgment a number of things, and I am concluding here because I know we've all got other places to be at this hour. Lord Burroughs notes in his dissenting judgment a number of things, that perceiving the death of a loved one should also count as a triggering event for the purposes of secondary victim claims. And what he highlighted is that claims for psychiatric illness by secondary victims succeeded in Walters, they succeeded in another case of Tredget, and that in 5 of the other 6 leading cases on the point, including Court of Appeal cases, nothing was said that there must be an event external to the primary victim, i.e. an accident. And all 6 cases dealt with omissions by clinicians to act, and there's no mention in any of them for this posing a problem to establishing liability for the secondary victims, for example, by the Court of Appeal in Walters. And in his view, he said it's an unwarranted backward step to insist that there must be an accident in the sense of an event external to the primary victim in order for there to be recovery. And he said it departs from the reasoning in almost all of the reported medical negligence cases in this area. His view, not that it is the law, but his view in any event is that the correct approach was to reject the focus on the respondent's submissions on accidents or events external, and to focus in these 3 cases on the death of the primary victim as the relevant event. His argument was there's good reason we can treat that as the relevant event, not least because it was witnessing the death of the primary victim or its aftermath that caused the psychiatric injury. And psychiatric illness was reasonably foreseeable, and all of the other established proximity and control factors are satisfied, acting as a brake on floodgates arguments. And on that analysis, the accident causing injury and the death could both be triggering events for the secondary victim claims, where the other control factors are satisfied. The 2 situations treat the same way, and there's nothing Lord Burroughs says that is unacceptable or irrational about so doing, and his dissenting view was that Novo should be overruled. Lord Burroughs didn't suggest that the only relevant event could ever be death, but he said that it would be either a correct application of the law to do so or a justified incremental step that falls well within the judiciary's traditional role of keeping the common law up to date. A further key point he made is that insisting on an accident being an event external to the primary victim needlessly denies recovery in almost all medical negligence cases, given that disease and illness tend to operate internally. And he said what is meant by accident may be regarded as drawing a somewhat arbitrary line. If you define it as an external event, that is a choice. It could easily, he said, be defined another way, and the death of the primary victim might be an accident because it is an event external to the secondary victim. And he asks rhetorically, why do some accidents count and others do not? If we think of a child that might sadly fall through a barrier into a river and die as a result of the failure to repair it by an occupier, and that child's witnessed by their mother, they recover, and even under the new scheme. A child's heart, though, may arrest as a result of negligent clinical failure to repair, treat their lungs with death witnessed by their mother. On his logic, these are both events arising from negligence, both external to the secondary victim and should be regarded as legally equivalent. But following Paul, they aren't. I'll leave you with some thoughts from across the divide, all again taken from the Law Society Gazette article. Gutted, represented many people in my career who suffered PTSD, thinking of those getting calls to say they have no claim today. And across the other side, to impose such responsibility for the health of members of the patient's family on hospitals and doctors would go beyond what in the current state of our society is reasonably regarded as the nature and scope of their duty. So that was it wasn't that whistle stop, but it is whistle stop because the decision itself is over 70 pages long and very detailed. It is worth a perusal in full, but hopefully that has given you the cliff notes, the précis of where we came from in terms of secondary victim claims, that history, and also where we have arrived at the current time. Right, I'm just going to open to any questions. James, have you seen whether there are any questions in the chat currently? Okay, does anyone have any burning questions that they wish to ask? If you don't want to ask them in a fully public forum like this, please do feel free to email either myself or James or any other of the Guildhall members to pose those questions. You might want to do so in a more private setting. Right. Well, I'm going to give a few moments just in case there are questions that people are frantically thinking up. But if not, thank you all so much for your time and for your attention in joining us today. I hope that that was an informative review of what is a very important and complex legal decision. As I say, please do not hesitate to ask us questions going forwards on these matters. The law isn't settled, particularly as regards wider non-emission type clinical negligence cases, and I think that there's going to be a lot of time spent considering those going forwards. I will therefore thank you to James and thank you to you all for your time and attention. I'll therefore sign off.